Well, hello. Welcome back to another exciting edition of Coffee with Stephen. So this week's blog is entitled Miller v. Becerra. We're going to be discussing another law case. Now, this one isn't completed yet. In fact, actually, it's just at the beginning stages. Some of you may have received an email from a number of different Second Amendment groups over the last couple of weeks, with a broad headline proclaiming that the assault weapons, California assault weapons ban is being challenged in federal court, and it's going to be heard by Judge Benitez. This is factually accurate, but the headline is a little misleading. The original case that has already been subjected to summary judgment would have been Rupp v. Becerra. Now, that's only in the Central District of California. Conceivably, another court case could come about in another district court challenging it. It hasn't gone up to the Ninth Circuit yet. But that decision is the one where Judge Stanton essentially said that the Second Amendment doesn't apply to semi-automatic firearms. And as you may remember from a previous blog, I took issue with that, obviously. This particular case is a little bit more nuanced, okay? Judge Benitez, you may remember, is the judge that gave us Freedom Week when he completely invalidated California's standard capacity magazine ban. This particular case dovetails with that original ruling. What they're essentially saying, the plaintiffs are essentially saying, is that in order to make a firearm California compliant, a lot of people have made their firearms fixed magazine firearms. They've gone with a Patriot pin or an AR maglock or something to that effect. Since it's a fixed round magazine, according to the California Penal Code, if you install a magazine that's capable of holding more than 10 rounds, you've automatically created an assault weapon. They're challenging that provision. So they're not trying to invalidate the entire statute. That they're really doing is they're trying to invalidate that very specific type of application. They articulate at the beginning of the complaint that it's both a fundamental as well as a, as applied violation of the Second Amendment, but then they focus exclusively on an as applied. Arguably, if they are able to succeed, it would essentially allow those individuals that have standard capacity magazines to be able to use them in their fixed round AR-15 platforms. That does not necessarily invalidate the entire assault weapons ban. That being said, it is Judge Benitez, okay, or as I prefer to call him, Saint Benitez. When something similar was presented to him in Duncan v. Becerra, rather than simply invalidating a very small portion of the statute, he essentially said the entire statute fails the Second Amendment and validated the entire thing. So it's not outside the scope of possibility that Benitez would do essentially the same thing and validate the entire law. We can certainly hope. We'd love to see it happen, but, there's no guarantee. In any event, hopefully you read the blog. At least get you up to speed on some of the jurisprudence that's taking place in the Second Amendment community. As always, train constantly, train consistently, train repetitively, and above all else, train with purpose. And most importantly, stay safe.